My partner and I argue on behalf of the state of Louisiana against Plessy. On June 7th, 1892, Plessy refused to ride the train car that he was directed to. Plessy was ruled that this was unconstitutional according to the 13th and 14th Amendments. Although Plessy is 7/8 white and 1/8 African American, he is still considered a Negro. Plessy previously argued that Louisiana denied him equal protection of the laws, according to the 14th Amendment. Equal protection of the laws means persons or groups of persons in similar situations must be treated equally by the state. Every person riding a rail car in Louisiana had to be directed by his or her car. Therefore, Plessy was treated with the same way as any white person would be treated. In addition, Plessy charged the restrictions in a sense reintroducing slavery by denying equality. Thus, the law also violated the 13th Amendment. Plessy argued that the state law stamps the colored race with a badge of inferiority.
Louisiana's Act 111, or the Separate Car Act, states that all railway companies shall provide separate but equal cars for whites and minorities. There was no proof saying that the minority cars were unequal in any way than the white cars Plessy decided that he needed to sit on. Under this act, officers have the power and are required to assign each passenger to the specified car. Also, the law states that any person who refuses to sit in his or her assigned car will be fined $25 or spend 20 days in prison. Most importantly, such refusal to the officer or the railway company the officer represents shall be liable for damages in any courts of Louisiana. If the officer refuses the passenger a ride, the passenger cannot sue. Plessy, knowing the law, and are not considered unconstitutional under Act 111.
On behalf of Homer Plessy, I would like to announce the 14th Amendment issue with slavery. You see, this whole issue brings up a whole load of slavery and all of its issues. The 14th Amendment abolished slavery, and it is insufficient to protect former slaves from certain laws which had been enacted in the South.
The statement is inaccurate because the 14th Amendment does not say that the states in the South cannot treat the whites as the same as they do the minorities. In this case, Homer Plessy was sent to his designated rail car Homer Plessy was sent to his rail car just like any other 100% white male would be.
How does the Separate Car Act have to do with your case?
The Separate Car Act is for our case because it's exactly what happens in the case. For example, Plessy was not on the right train, so he was directed to another train for his race because he was 1/8 black. And under law, he is still considered a Negro. So it has everything to do with it. Thus concluding that this act was unconstitutional and Plessy was forced to go to a different train for his race.
This does not violate Plessy's 14th Amendment rights because the Supreme Court of Louisiana passed a law so that Act 111 does not violate Plessy's 14th Amendment rights because in the amendment itself, in the act itself, it says that as long as the cars are separate but equal, that Plessy had to go to a separate car. There is no proof that the minority car was any different from the white car. Therefore, the state of Louisiana did not break any constitutional law.